passed by that has been passed by the various courts like High Court, Supreme Court of India. So to start with, I would just like to share a PPT with you all. Can you please confirm whether it is visible or not?
Yes, it is visible.
Okay, thank you, Shriram sir.
Yes.
So to start with, we all have heard about the phrases like vocal for local, self-reliant India, Atmanirbhar Bharat. And as far as I remember or I can recall, these all phrases has been used, I think, mostly after 20 after the year 2022, that is post COVID. The government has recognized the importance of MSME sectors, and they have regarded them as the backbone of the economy, as the backbone of the India. I'm sure you all are aware that the MSME sector is contributing a significant part in the country's GDP from the last many years. And 6.3 crores of MSMEs are registered with the Ministry of MSME till today. So just as Lakshita has already introduced, I already quoted that MSME stands for, just a minute. There's some problem with my screen. Just allow me to share it again. So MSME stands for micro, small and medium enterprises. MSME are regulated by the MSME Act, which has been introduced by the Ministry of Micro, Small and Medium Enterprises. So in the year 2007, Ministry of Small Industries and Ministry of Agro and Rural Industries have merged to form the Ministry of MSME. The act which is applicable to the MSMEs are MSMED Act 2006. So I would like to discuss few of the definition that has been prescribed in the MSME Act. First of all is appointed date. So what is appointed date? Appointed date is the date following the day MSME is appointment date is the date following the date immediately expiry of the period of 15 days or the date of acceptance. I think there is some problem with my screen. Yes, sorry. Yes, sorry. To continue with the important definition, that is the appointed day. So appointed day is the day following immediately after the expiry of the period of 15 days from the date of acceptance or the day of deemed acceptance of any goods or any services by a buyer from a supplier. So we are aware that the date of acceptance or the day of deemed acceptance are the important two components while determining the appointed day between the buyer and the supplier. Now, what is the date of acceptance? Date of acceptance is the date of actual delivery of goods or services, or the date on which such objection is received from the such objection is removed by the supplier, where any of the objection is received in writing by the buyer. Suppose the buyer gives his or her disconsent or gives his objection in writing to the supplier regarding any goods or services that he or she has received in the course of business within 15 days from the date of delivery of the goods or rendering of services. So on the day on which those objections has been removed by the supplier will be the date of acceptance.
Ankita, you have to also say that from the
Yes,
day
sir.
when if you supply the goods, the day when they are received, within 15 days, they have to raise an objection if there is a defects. If
Yes,
they are not
correct.
raised any objections, it means they have accepted it. That's it.
Yes, that
After
we will
two
discuss.
years, after 2 years or 3 years, they cannot come and say that there is a dispute in the goods they supplied. It is not accepted.
Correct, sir. That is why they have already, the act has also described the day of deemed acceptance.
Yes.
Yes. So the day of deemed acceptance is that day on is the day of actual delivery of the goods or services. Now, as Sriram sir has already mentioned that if the buyer has not any objection in writing, or he has not provided any objection in writing for the goods that has been supplied by the supplier to him within 15 days from the date of delivery of goods or rendering of services, then the date of actual delivery of the goods or services will be deemed as the date of acceptance in this scenario. Now, I frequently get, as I appear before the council, I frequently get this question from many of my clients that why trading sectors or trading industries are not allowed to file a case with the MSME. So I think the answer is in the definition itself. If we see the definition of an enterprise, enterprise means an industrial undertaking or a business concern or any establishment by whatever name called, engaged in a manufacture or production of goods in any manner pertaining to any industries specified in the first schedule to the act, or engaged in the providing or rendering of any services or service. So it is clearly mentioned that the manufacturing or production industry and the industry which is engaged in rendering of services will be allowed to take their cases to the enterprises, and they can file cases before the council. Now, what is the criteria for classification of MSME? So with effect from July 2020, there has been a revision in the category of classification of MSMEs. Now the manufacturing or service industries can be categorized based on the investment in the plant and machinery or equipment in three categories, that is micro, small and medium. If you see the figures that I have mentioned, you can see that it is in the multiples of 5. Like for micro, investment in plant and machinery or equipment excluding land and building not more than 1 crore. And please friends, see that this is and not or. So you have to see both of the criteria: investment in plant and machinery or equipment and annual turnover not more than 5 crores. For small, investment in plant and machinery or equipment not more than 10 crores and annual turnover not more than 50 crores. And for medium, it is investment in plant and machinery or equipment not more than 50 crores and annual turnover not more than 250 crores. So this is all the multiples of 5. Easy to remember. This is a trick which we used to remember, which we used to just remember this. Next is about the registration of MSME. So we all are aware that before the year 2020, the MSME sector, the MSME enterprises were required to get the Udyog Aadhaar memorandum that we know as UAM, Now, after 2020, the act has been revised and certain amendments has been brought, according to which now the enterprises which wants to get registered under MSME Act will have to do the Udyam registration. And after this registration, they will be getting a Udyam registration certificate. Earlier, it was Udyog Aadhaar Memorandum. Now the name has been changed and it has been revised to Udyam registration certificate. Now, what are the key features of this registration? It is very easy, fully digital, fully online. No hard copies are required to be submitted, or no documents you have to submit. You just have to fill the details like the PAN of the applicant, PAN of the enterprises, the bank details of the enterprises, the number of employees that are working in the organization. Certain things are needs to be given in that online form. No need to upload any document, and there is no fees that has been that is required to be paid for registration to the government. Upon filling all the details, instantly you will receive the instantly you can generate the Udyam certificate along with the entire application form, and you can save it with you for future use. Now there is no need to renewal of registration. This is a lifetime registration. The registration is valid for a lifetime. And yes, depending on the annual turnover of the company and the idea that has been filed with the income tax department, the registration keeps on updating. That we have discussed the criteria of the MSMEs. Suppose your turnover exceeds rupees 50 crores and it goes in the category of medium. So automatically your enterprises will be regarded as medium enterprises, depending on the idea that you file with the income tax department. Now, any activity can be added. Any number of activity can be added in one registration. Suppose you are carrying on 4 business activities, you can add all those 4 business activities in your registration form. Now, from 1st April 2021, PAN and GST numbers are these two things are important and mandatory for all the enterprises who are willing to get themselves registered under MSME. It is very important for them to have a PAN and GSTN. Now, let me just discuss with you all about the benefits of registration under MSME. So the first benefit is there are so many benefits under registration for registration under MSME. If you get registered as a MSME enterprises, I have just quoted few of them. The first of all is collateral free loans are provided by the banks depending on the documentation, on the evidences, on the papers that you submit with the bank. They provide you collateral free loans. Now the interest rates are minimum in case you are a MSME registered organization. There are many schemes and benefits that are available to the MSME registration, which you can also see on the on the MSME Champions portal. There is a portal which has been introduced by the Ministry of MSME, which is known as MSME Champions portal. There you can see various schemes and benefits that the ministry is providing to the MSME enterprises. Next is you can apply for the government tenders very easily. You can apply for the government tenders on the basis of the documents that you submit on the government portals. You can avail the benefits of getting government tenders. Become eligible for priority sector lending for banks. Now you get concession on electricity bills also. Direct exemptions on income tax for the first year of business. Subsidiary on barcode registration helps in dealing with delayed payments. So there is MSME has introduced a portal many years back. It has introduced a portal, MSME Samadhan portal, where in case the MSME enterprises is getting delayed payments from their buyers, they can always approach this platform for getting their payments on time. So there is certain a detailed process which you have to follow for getting recovery of your delayed payment. Now, under the MSME Act, what is the liability of buyer to make payment? the buyer shall make payment on or before the date agreed upon between him and the supplier in writing. Suppose there is a written agreement, the buyer and supplier enters into a written agreement. So the buyer will have to make the payment on or before the date that has been agreed between him and the supplier. Or in case there is no written agreement, then the buyer shall have to make the payment before the appointed date. So we have already discussed the appointed date. I think you all are very clear about what is the appointed date. So now the payment agreed upon between the supplier and the buyer in writing shall not exceed 45 days from the date of acceptance or the day of deemed acceptance. And this is simple. If the buyer has taken any goods or services from the supplier, the buyer will have the period of up to 45 days from the date of acceptance or from the date of deemed acceptance to make the payment. And if he or she is not making the payment within this timeline, then the supplier can always approach the MSME council. Now, do you know what is the date from which interest is payable by the buyer for failure to make payment to supplier? From the appointed date or from the date immediately following the date agreed upon between the buyer and the supplier. Now, there must be some rate of interest also. If there is delay in payment, there is a rate of interest which has been prescribed by the Act. So what is the rate at which interest is payable by the buyer for failure to make payment to supplier? The buyer shall liable to pay compound interest with monthly rest. Please pay attention. This is monthly rest, not quarterly rest. So the buyer shall have to pay compound interest with monthly rests to the supplier at 3 times the bank rate notified by the Reserve Bank. So it is 3 times. Suppose the bank rate, the current bank rate is 6.5%. For say, it's 6.5%. So 3 times of 6.5% along with compound interest, which will be compounded with a monthly rest. Monthly, you have to compound it. Next, the Ministry of MSME wide notification dated 18th October 2020 has brought significant changes in classification of enterprises. Now, this is very interesting. This is a very interesting amendment that has been brought by the ministry. Suppose your enterprises is registered as a as a small enterprises, and there is an upward change in the turnover, in the annual turnover of the company or the enterprises. So if there is any reclassification of any enterprises, so from small, suppose from small it goes up to medium. So in that scenario, the enterprises will continue to avail the benefit of the category in which it existed before reclassification for a period of 3 years. It can avail the benefit of small enterprises up to the period of 3 years. Am I clear?
Yes, you are clear.
Thank you, sir. Okay. So let's just discuss some of the judgments, some of the landmark judgments. First is Uni7 Engineering and Infrastructure Private Limited versus MSME Council. So it was held that MSMED does not contemplate a scheme for the buyer approaching the facilitating council under Section 18 of the Act for recovering any monies from the seller. Just before telling you all about the judgment that has been given by the court, let me just discuss the background of this, the facts of this case. So what happened? The supplier has taken the buyer to the MSME council, and what the buyer has did, buyer has filed a case. Buyer has also filed a case against the supplier, referring that the enterprises, that the buyer is also a registered MSME enterprises, and that buyer has demanded for recovering of money from the supplier. So in that scenario, the court has held that the MSME Act does not contemplate a scheme for the buyer approaching the council under Section 18 of the Act for recovery of monies from the seller. It is the seller who can independently claim the money from the council, but the buyer would have to have the right to make the counter claims. However, it cannot approach the council on its own. The second judgment is of Tirupati Steels versus Shub Industrial Component. So it is in this whole case law, it was there. The question is whether pre-deposit of 75% of the awarded amount as per Section 19 of the Act is mandatory to challenge the award. We all know that Section 34 of the Arbitration and Conciliation Act 1996 gives the power to challenge the award, that is, to challenge the arbitral award. So in this case, it was held that the requirement of deposit of 75% of the amount in terms of the arbitral award as a pre-deposit under Section 19 of the Act is mandatory before making an application to the under the Arbitration Act. Next was Delton Electricals versus Maharashtra State Electricity Distribution Company Limited. The question was whether the Limitation Act 1963 is applicable to the claims made under the Act. So the court has rejected the contention that by virtue of Section 43, read with Section 2, Section 2 of the Arbitration Act, the Limitation Act is not applicable to the arbitrations. This is a very important judgment, and this is a very interesting judgment. In this judgment, they have set aside the limitation act, and they have concluded that the arbitration is not, that the limitation act would not be applicable to the statutory arbitrations. Taking into consideration that the limitation law has a beneficial purpose, it held that an interpretation which allows the council to make an award on time barred claims can't be taken by the court. Further, it was held that such award should be set aside on the ground of violating public policy. The fourth judgment was Uttarakhand Power Corporation Limited versus Mahavir Transmission Udyog Private Limited. In this judgment, the question was whether the deposit can be made in modes of payment other than cash. So, relying on the judgment in Goodyear India Limited, the court held that the deposit under Section 19 has to be made in cash. I have just discussed about the pre-deposit of 75%. So this is related to that only, that the Section 19 has specifically tells that the deposit has to be made in cash, and that it has no discretion to allow the deposit to be made in any other form, such as bank guarantee or other security. Further, the court held that the proviso to Section 19, which requires the court to order some percentage of the deposited amount to be paid to the supplier, makes it very clear that the legislature intended to have the deposit by cash only. The last judgment, this is a very recent judgment that has been passed by the High Court of Delhi. Sterlite Power Transmission Limited versus EPC Solutions LLP. So the question was whether the Micro and Small Enterprises Facilitation Council can entertain references to arbitration from medium enterprises in addition to those made by micro or small enterprises under MSME Act. So in this particular judgment, it was held that the medium enterprises can approach the council if it was a micro or small enterprises at the relevant time. Now, what is the relevant time? It has further explained that the relevant time shall mean the date of agreement between the parties and the date of supply of goods or rendering of services. So it means if your enterprises is a micro enterprises or small enterprises at the time when the agreement has been entered into by the buyer or supplier, then then you can avail the benefit of that micro or small enterprises, irrespective of the fact that in today's date you are come under the definition of a medium enterprises. Okay, so I'm done with all the judgments. now I would request Sriram sir to kindly conclude this session.
Uh, Thank you, Aikita, for giving this session. Very nice.
Thank you,
And
sir.
I wish to say that the benefits of registration, you have given some points. I want to say 2 points in addition to that. For MSMEs, the trademarks registration fees is only 50%. Okay, if they are registered as an MSME, and the trademark fees will be 50%. And for income tax benefit, the company or any entity is registered as an MSME. In any year, if the transaction into online mode, that is all the cash tax. No, this transaction is 95% of the transactions are through online only. There is no tax audit up to 5 crores under the Income Tax Act 1961. And regarding this agreement where you have said that is 45 days. So the agreement, anyway, the agreement should not consist that it can be paid more than 45 days. So it should be restricted for up to 45 days only. And if anything is more than 45 days, it is not acceptable. Okay, between supplier and the buyer. This is
Yes, yes, absolutely, sir.
yes. Then rest of the things it's fine. Okay, taken very nice session. And anybody has any doubt, they can also.
Yes. If anybody has any doubt, they may ask. Okay, I think Shriram sir, what we
Yes.
have not covered in this session is about the recovery proceedings
Yes.
that we take to the MSME Council.
Yes.
Just to give a glimpse of that particular proceeding, I
Hmm.
would just like to say that for recovery of the amount from the
Hmm.
MSME Council, the enterprises, the micro and small, one thing is that the medium enterprises cannot approach the council. It is very clear that
Yes.
the medium enterprises cannot take their cases. But yes, after this recent judgment that has been bought, if we consider that the enterprises registered as the micro or small in the previous years, then at the time when the goods when the goods or services has been supplied, or the agreement has been entered into between the buyer and supplier, they can definitely go to the council. So for going to the council, first of all, the supplier has to file a case on the MSME Samadhan portal online. They have to file a
Yes.
case, and they have to give 15 days of time to the buyer for replying to that case. And then if the buyer do not reply, then automatically that
There is
case
no
will be
mutual
converted.
settlement. There is no
Yes, yes,
mutual
correct.
settlement happened.
Hmm. Yes. So automatically that
Then they have
reference
to
will be
file.
converted into an application. Then you will be given a date for the hearing. Upon that date, you have to give your pleadings, and after the pleadings, you will have to submit an application in that format. That is,
Firstly, firstly, it is and conciliation proceedings will start.
yes,
The
correct.
MSME Council will call both the parties for amicable settlement. They will
Yes,
not accept any arguments at that stage. Okay.
correct.
The conciliation officer will try to bring the settlement, bring the two parties for settlement. If the conciliation fails, then the matter will be posted for arbitration. In arbitration only, they counterclaim or claims or counter replay, whatever it is, it will be adjudicated by the arbitration tribunal. The arbitrator will be mostly be the MSME themselves, or if they require, they can pass this arbitration proceeding to fix some other institute to do this arbitration. Okay, so in the
They
arbitration,
always appoint some arbitrator for these cases. Mostly their mentality is, sir, to settle the cases only between the buyer and the supplier.
yes, because why this settlement is taking place is because if any award is passed along with the interest, they have to pre-deposit
Attach.
70% before
Yes,
going for appeal. So that
correct.
will be very costly for them. So they will try to settle the matter amicably. That's the
Yes,
success of this MSME Act.
yes.
Okay. And after this MSME award, the arbitral award, what will happen is you have to make the payment. If they are not made the payment, then you can file and petition in the executive magistrate court
Hmm.
for execution of the petition. Okay. In that execution magistrate court, you can say that arrest warrant can be issued or attachment of
Attached
properties.
properties there,
And
yes.
in some cases, it will the properties or bank account will be attached and money will be collected as an arrears of land revenue. So the rules are very strong in favor of MSMEs only. So the suppliers can get this benefit by filing the case before the MSC Facilitation Council.
So most of these small enterprises actually are not aware of, the act or the rules and the rights they have under this act. And I feel that is why most of them do not approach the council itself.
Yes. So firstly, they have to know, they have to register this MSME Udyam registration.
Yes,
Without this registration, they will not get any benefits.
correct.
So before that, they have to get this registered done, and after that only they can avail these benefits.
Yes, correct. Right, sir. So any questions from the participants?
UMS.
Yes, I can see one question in the chat
Yes.
that Pooja Kalwar has asked. So my UM mentioning Udyam enterprises and Udyam registration showing small enterprises. Can we file application for default under MSME Samadhan portal?
Yes. Udyog Aadhar memorandum is prior to Udyam registration. Okay. So Udyam registration is came only on 2020. Udyog Aadhar is came on before that itself. So in 2019, if they are medium, not medium, they are small, they can avail the benefits up to 2022.
No, so I think here what is important is to see whether what is the
Relevant
date
time.
of the invoice.
Yes,
Yes,
in
the
relevant
date.
time, they are very small or medium, micro, they
Yes.
can file the case. No
Yes,
issue.
suppose it is
Based on High Court
after
jurisdiction.
getting the Udyam registration, if the invoice is raised or a agreement has been done after
Yes,
getting the Udyam registration, then definitely Pooja, your enterprises can avail the benefit of small enterprises and file a case of MSME with the MSME Samadhan portal.
yes. One
Okay.
thing is here, there is no threshold limit. You can file for even smaller amount, 50,000 or 1 lakh.
Yes.
Okay. And another one is the case can be filed where the supplier resides, not where the buyer. In some other acts, we have to file the case where the buyer resides. In the MSME Act, the case will be filed where the supplier resides.
Supplier. It is the
Sorry,
petitioner. Yes,
supplier
whether
resides.
yes, whether the petitioner resides, you have to. This is a very
Yes,
interesting thing, and
yes,
most of us don't know this.
yes.
We have to file a case with the jurisdiction of the supplier,
Jurisdiction
not
of the
with the
supplier.
jurisdiction of the buyer.
Yes.
Right. Yes, sir.
Arbitration proceedings will not fail. It will have some result. Either they will accept or they will reject your claim. So for a supplier, they can go to the court. Only for the buyers, they have to deposit the award amount and go to the appeal. For the suppliers, they no need to deposit any amount. They can go directly to the High Court for making an appeal.
Right.
Any other questions? Any doubts? And for registration now, GST is not mandatory now, as of now. After some amendments have came, GST number is not required mandatorily for registration in Udyam registration. For
Yes,
Udyam
this
registration,
is subsequent to some changes in the GST laws also
yes, yes,
have
yes.
been introduced.
So someone has raised a question. What if the arbitration?
Award is not followed by the respondent, then what will be the
You
consequences?
have to file an executive petition before the magistrate court. You have to file a petition for the execution of the order of award under section 34 of the Arbitration Act.
Okay, that is fine then. Any other thing that the audience would like to say or discuss?
नहीं सर, एक्चुअली बेस रेट से हम लोग माइनस करेंगे ना, ये है हम लोग का ओल्ड रेट जो लास्ट टाइम हम लोग रेट कोट किया था।
अभिजीत जी, मिस्टर अभिजीत,
I'm sorry, no question.
Okay.
thank you. Okay, I think if you want to say, okay, we got one more question, sir, from Vishal. Is there any legal disqualification in a case is decided after 90 days as stipulated in the act?
No. There is no disqualification. And for valid reasons or sufficient reason, the days may be extended. I have appeared before many cases, for many cases in MSC Council. It is taken time for more than 90 days. It is for the council recording the reasons for extending the period for adjudication. There is no issue. If the both parties wants time to file their claims or have some settlement talks, conciliation officer can give the time, not an issue. There is no disqualification, legal disqualification.
Okay, so we have one more question. Whether an award holder from MSME Council can gain any preference as creditor in IBC proceedings?
As of now, IBC Act is not amended to give any preference for MSC suppliers. So they still remain as an operational creditor only for supplying the goods. And in some cases, the arbitral award is not accepted for filing the applications.
We are yet to see that light. Okay. So I think there are no more questions that our audience would like to ask now. So in case anyone has any query, they can write back to us and we would be happy to take up any of the queries.
Yes.
So thank you.
Thank you, Lakshita. That is Lakshita. Vote of thanks. We will see.
I would like to thank both our respected seniors for their efforts in taking such an enlightening session. I am sure we all have benefited from the same. And I would also like to thank all my colleagues and peers for joining us for this session. We all look forward to your constant participation like this in our forthcoming sessions. Thank you.
Thank you, Lakshita.
Thank you.
Thank you, Sriram sir.
Thank you.
Thank you everyone
Thank
for
you,
joining.
Thank you, Madhuri.
Thank you.
Thank you,
It was
Sudha
very
ma'am.
nice session. Thank you so much.
Thank you,
Thank you.
Shikhari.
Thank you. Thank you. Bye.